Karabo, thank you so much for joining us, and congratulations, I probably should say, on this court's findings. Now, if we can just get into it here. I'm quite interested to read the senior counsels that represented the State Security Agency argued that journalists were not entitled to dictate just how Rica should be implemented in order to accommodate them. I'm sure lawyers acting on your behalf said, well, that's exactly the point, isn't it?
Yeah, that's correct, Marcel. It was extraordinary that the state would even seek to make such an argument, because ultimately the ability of journalists, and particularly investigative journalists' ability to do their job, is based on their ability to communicate confidentially with sources. And this is to ensure that the sources know that they will not become vulnerable when talking to journalists, and to protect them from potential harm. And so what we said in our application to the Gauteng High Court was that when a warrant is issued by the designated judge, that judge should consider the fact that there is a journalist or anybody else who's got a duty of confidentiality in their work. And that should be a factor that's considered as part of the judge's consideration when granting an interception to tap the phone of a journalist.
Now, when this Rica Act came into play a few years ago, probably more than a few years ago, we needed to go to the bank, we needed to go do Rica there, your cell phone details, all of these very day-to-day mundane things. Did we as a South African public not pay more attention to the finer print of that act that would have allowed government's tentacles to reach into the surveillance of our phone calls and our phone records?
Rica came into effect shortly after 2002, and that was a different time. It was a different context. It was soon after 9/11 happened in the US. What we then argued in our papers was that since 2002, there's been a rapid development in the technology available for the state to conduct its surveillance. And so based on that, we said inherently Rica was unconstitutional because it failed to have the necessary safeguards to ensure that other rights, such as the right to privacy, the right of freedom of expression, as well as access to justice, were not met. But this became particularly more aggravated with the developments in technology, which meant that the state potentially had the ability to be even more intrusive in the way that it undertook its surveillance. And so we said, given these developments, and given that inherently the law itself was unconstitutional, it needed to be reformed, and reformed with urgency.
Do you have an understanding of what segments of the Rica Act has now been deemed unlawful, and what are the next steps now?
Yeah, there are several aspects of the Rica Act which were deemed unconstitutional, constitutionally invalid. But perhaps what's easiest is to break the two parts of our challenge. So the first part dealt with these unconstitutional aspects of Rica. So, for example, the lack of the consideration of a journalist or a lawyer being the subject of surveillance, as well as saying that the appointment process of the Rica judge needed to be much more independent. So currently the process is the Minister of Justice simply makes an appointment. We said that there needed to be more inherent independence to give the public confidence that the Rica judge would be making judgments in the public interest rather than at the behest of the executive. But I think an important part to highlight in the judgment is the court's view on bulk interception. Now, this would potentially affect every person living in South Africa as well as in other jurisdictions, because this allowed the state to, with absolutely no reason, target the internet signals of all people who work online. So that's your internet traffic. It's the metadata, so it's not the content, but it's sufficient information to be very revealing. What is, I think, hugely significant is that the judge in the decision today said that in itself is unlawful. In our application, we had said that the state is conducting bulk interception with simply no legal basis. So it's being conducted unlawfully. And I think that the court has agreed with that is significant for every person who uses a telephone as well as the internet in South Africa and beyond.
So what happens next now? Do we know if there's going to be an appeal of some kind from the State Security Agency? And is Amabhungane perhaps considering taking this matter forward by suing the state?
We will have to consider our options. You'd need to talk to the state about whether they're considering appealing, particularly on the bulk interception ruling. The Constitutional Court will need to confirm this judgment, of course. What has also happened as a result of this judgment is that Parliament will have a responsibility to to reform Rica, so to redraft the legislation to ensure that it's constitutionally compliant, and this will happen within Parliament has been instructed to do this within a 2-year period.
Okay, thank you so much for that update. Karabo Rajuli joining us from our Cape Town studio. Thank you so much. She's with the Amabhungane Centre for Investigative Journalists. A very interesting finding handed down there.